Thank you very much. My name is Bill Gibbs. I'll be the host for the session. It is a great pleasure to have you here today. The session is being recorded. We're going to send a copy of the recording and a link to the slides to all participants today. We'll be hearing just a little bit from Dr. Ilia Kolochenko on cyber law, cybercrime investigations, and response. And I'll introduce Dr. Kolochenko in just a moment. Here's the agenda that we'll be following today. It's pretty straightforward, and if you have joined us for other sessions, you'll know that it's pretty much the same format that we always follow. I have a few housekeeping items. I'll talk a little bit about capital. I'll introduce the presenter, and then the bulk of the time together will be the presentation. Toward the end of the hour, we'll open the floor for questions and answers, and we'll do that via text chat. I'll explain that in a moment. We'll talk about upcoming webinars. We have 2 webinars left in this academic year, and how to get a copy of the recording, slides, and certificate of attendance. I asked in the text chat earlier how many of you were students or alumni or faculty, and I see that many of you are, so I'm telling you things you already know. But in case there happens to be a new person that doesn't know much about us, Capital has been around for a long time. We'll celebrate our 100th anniversary this year. One of the very few institutions in the entire country that's private and dedicated to all things STEM. And we've been doing that for a long, long time. We offer fully accredited degrees from the associates, bachelor's, master's, up to several different doctoral level degrees. We're nonprofit, private, and accredited. I could take a lot of time to unpack all of those, but most of you are in education and understand what this means. Our accreditation is regional accreditation, which is the highest level of accreditation available to any university in the United States. We'll talk right at the very end of the presentation about some of the degrees that impact this presentation, or this presentation would impact. But for now, I want to make sure that we get right into the presentation. We'll answer questions at the conclusion of the presentation, but you may post them at any time in the text chat, and we'll answer as many of the questions as we can. We'll return to the text chat to make sure we go through the questions. I'm not activating microphones or webcams for participants at this time. And as I mentioned earlier, we'll be sending a link to the recording and to the slides to all of the registrants for the session today. We'll also be posting the recording on our webinar webpage and also on our YouTube channel. And finally, a participation certificate is available. I'll talk more about that at the end of the presentation. With that, let me get right into the presentation's presenter's information. And he is going to share a slight more of information about himself in his remarks. So I'm going to keep my remarks fairly brief. He's adjunct professor of cybersecurity and cyber law at Capital, and also a faculty member at the DC Bar teaching cybersecurity for lawyers and law firms. It's a continuous legal education course. He's originally from Switzerland. He's a jurist, author, and cybersecurity expert with over 15 years of experience in information security auditing and cybercrime investigation. He's a lawyer admitted to the DC Bar in Washington, DC, and is a partner and cybersecurity practice lead at Pratt Law, LLP, where he advises corporate clients on data protection, cybersecurity, and privacy law. He's also the chief architect and CEO at IminiWeb, a global application security company located in or headquartered in Geneva, Switzerland. That company has served over 1,000 enterprise customers and is the recipient of numerous awards. Dr. Kolochenko earned his BS in computer science and mathematics from Webster University, an MS in criminal justice from Boston University, an MLS from Washington University, a Master of Laws in Technology from the University of Edinburgh, and a PhD in computer science from our own Capital Technology University. He's currently pursuing his second LLM in cyber intelligence and national security at George Mason University. Now, with that, I want to give control. Bear with us a little bit as we make the transition from my slides to his. So we'll just go ahead and I'm going to stop sharing and then give him the share capabilities. There we go. I can see the slides, and
excellent.
So we're ready to go.
So good morning, good afternoon, good morning, Bill. Thank you for having me here today. We'll be talking about cyber law. Just to set some expectations, unfortunately, we'll not have time to go into all the details, but the goal of this webinar is to paint a broad picture of cyber law, how it works, and how cybersecurity professionals can reduce their corporate and personal legal risks. Okay. So let me start sharing my screen. So very brief introduction. I've been in cybersecurity practice for more than 15 years. I'm also a lawyer, so this is actually why we are talking about cyber law today. Any questions about compliance, cybersecurity, cybercrime investigations, or cyber law are welcome. However, important disclaimer, no legal advice. Unfortunately, it's my duty to make it. Okay, so I'm not your lawyer. And if you need a legal advice, please talk to your lawyers. Okay, I'll be sharing my personal thoughts, opinions, and experience. All right, so let's start with a high-level slide talking about countries around the globe that have cybersecurity, data protection, or privacy legislation, because most of you probably believe that when we talk about cybersecurity law, it's about European GDPR or Californian CCPA and some other emerging state law in the US. But actually, we have over 170 countries in 2024 with some form of data protection, cybersecurity, and privacy legislation. Of course, probably European countries and some countries in Asia-Pacific region, and obviously US have the most developed and at the same time the most complicated legislation. But virtually in any jurisdiction where you may have clients or partners, you have cyber law that may apply to your business. Okay. Now let's talk about the United States specifically. Okay, so this is a great map provided by the International Association of Privacy Professionals, and you can see that quite some U.S. states already have state privacy law. This is actually very specific to the U.S. situation because we still have no overarching federal privacy law. We'll talk about this in a moment. So states pioneer and implement their own state privacy legislation. I guess most of you have heard of Californian CCPA and CPRA, but as you can see, we have many states with privacy laws that control how companies handle and protect their personal data. Okay. One important caveat here is that you can see Illinois, for example. You can see it in light blue. It means that there is still no comprehensive privacy law, but this simplicity can be somewhat misleading because Illinois has a fairly well-known BIPA. This is a Biometric Information Privacy Act. This is an Illinois state law, okay? And it is famous because Facebook several years ago paid the record $650 million settlement for the alleged violations of BIPA. So even if you see this beautiful state map, and you don't see that your state is in green, it doesn't mean that you don't have, sector-specific laws, okay? So having said this, let's have a look on the current stack of data protection and privacy laws and regulations. We'll talk a little bit about European countries at the beginning. So we have what I call it supranational laws. For example, the EU's GDPR. This is law that becomes national law in all EU member states. Okay, so as soon as a regulation comes into force, it becomes national law of all EU member states. This is, let's say, somewhat different from directives. For example, NIS2 directive. This is where the EU rather sets up some objectives, some goals, and EU member states have to implement national legislation to attain these goals. Okay, EU DORA, for example, this is a regulation, meaning it applies as is in all EU member states, same as the EU AI Act. Okay, so it can be somewhat complicated. Now, let's talk about national laws. For example, in Switzerland, we have recently introduced Swiss new law on privacy and personal data protection. It's called New Federal Act on Data Protection, NFADP. It is like in a Swiss GDPR. We have Brazilian LGPD, we have Singaporean PDPA. So these are national laws, but frequently when you do business with those countries and you have your clients or partners there, you must follow these laws. And it is becoming increasingly complicated because you may have no physical presence, no offices, no employees, no subcontractors based in a specific jurisdiction, but if you do business there, if you have some clients there, or if you undertake some substantial marketing efforts, you will likely be required to follow their laws and their rules. Let's talk about US specific stack of laws and regulations. So we have state laws like the New York Shield Act or California CCPA, Illinois BIPA. Federal legislation that is controlling some areas like healthcare or governmental agencies. We also have administrative rulemaking processes. For example, when an agency like the SEC imposes certain disclosure rules on the publicly traded companies, or when FTC regulates financial companies that are not subject to GLIBA. So it can be pretty complicated. And you also have executive orders when the US president orders certain things to federal agencies. For example, Joe Biden's executive order on the improvement of nation's cyber security, where he implemented certain new cyber security and interrelated requirements for the US federal agencies. You can also have guidelines incorporated into national law. For example, in many state laws, you have US NIST special publication series that are incorporated into state law, because obviously lawmakers have much better things to do than designing their own cybersecurity standards or guidelines. So they simply say that you must follow this specific special publication or framework, or FIPS, Fair Information Practice Principles. They are incorporated in some federal and state law relating to privacy and data protection. Okay. You also have some mandatory governmental framework or standards. For example, if you are doing business as a company with the US Department of Defense, you must follow certain cybersecurity and data protection requirements. Okay. Likewise, if you are doing certain private activities, for example, if you are accepting payments with credit cards, you contractually agree with PCI SEC to abide by the PCI DSS standard. Or for example, if you are, as a bank, you are connected to the SWIFT network, you will have to comply with their cyber security controls and regulations as a matter of contract. Okay. And last but not least, you have private frameworks. And once again, you have no duty per se to comply with SOC 2 requirements, to be ISO 27001 certified entity, but your clients, for example, may require you to be compliant. Otherwise, they can break your contract with them, or they can impose sanctions permitted under contract law in your jurisdiction. So as you can see, it can be pretty complicated, and we'll not even talk, being mindful of time that we have, about certain complicated cases when you may be both subject to state and federal law. We'll not be talking about preemption. These are comparatively advanced topics, but as you can see, we have a convoluted and complex stack of laws, rules, and regulations. Now, a reasonable question one may ask, Ilia, why does it all matter? I don't care. I'm a cybersecurity professional at the end of the day. That sounds fair, okay, but let me share some recent numbers from 2023, okay? So these are the largest fines, penalties, or settlements from 2023. Credit goes to CSO Online. And you may also reasonably object, saying, Ilia, well, these companies certainly have a lot of money. We don't really care, their shareholders will get less dividends. Makes sense. But let's talk about another important and alarming trend that we have. So you certainly, I think most of you certainly saw this sad news when cybersecurity executives have been criminally prosecuted and convicted for cybersecurity incidents and data breaches implicating their employers. And we can have a dedicated webinar about each of these stories, but we'll skip it for now. Just to tell you that now regulators, and it's not only in the US, it is, I would say, global practice, when regulators and lawmakers, they believe that imposing sanctions on companies is just baseline, but also, some individuals, most likely, executives and cybersecurity professionals must be punished as well. So they believe that liability for cybersecurity is not a corporate liability anymore, but it's a corporate and individual liability as well. So just to illustrate, this slide with another example, this is not very famous case, but it is important because this is an FTC order against an executive of a breached company. Why it is remarkable? Because FTC made it clear and then emphasized once again that this order is like, permanent order. So FTC ordered that whenever the CEO of the breach company goes, he is required to implement a comprehensive cybersecurity strategy and program at his new company. It means that he was ordered not just to fix all the problems at his current job, but FTC said, really, we don't care. Whenever you leave your current job and you become a C-level executive or board member anywhere, you will have to implement the very same cybersecurity strategy and make sure that data of your customers is properly protected. So this is like a lifetime order. And violation of the FTC orders can be costly, okay? Interestingly, just need to share some historical context here. The FTC Act was enacted in 1933, I guess. And FTC today, many legal scholars call it the federal cyber regulator. And I agree. So FTC is probably one of the most active federal agencies dealing with cybersecurity, data protection. And the FTC has been successfully utilizing Article 5 of the FTC Act that deals with deceptive or unfair trade practices. When you, in a nutshell, overpromise to your customers that their data is protected and eventually you underdeliver, you suffer a disastrous data breach, and later on it is discovered that you had no even the most fundamental security controls. So basically, we don't really need new legislation to deal with AI, and this is my personal opinion. We have enough laws and regulations to deal with cybersecurity, though a federal data protection and privacy law will certainly be helpful. So let's talk a little bit about other details. Okay, so how to survive for cybersecurity executives, for their companies, what to do. Okay, what's the solution? Once again, disclaimer, no legal advice. I'm just sharing my personal experience and my personal thoughts and opinions. Okay, so let's take the EU NIS 2 directive. Okay, this is one of the recent EU-wide legislation. So this is a directive. It means that EU member states will have to implement it into their national legislation. So it will be similar, but variations may exist. Okay, so let me share some of the key elements of Article 21 that actually describes cyber security controls and procedures. Okay, and I'd like to attract your attention that this is a very high-level directive, and countries will have some leeway when implementing technical details contrasted to, for example, EU DORA, that applies to EU-based financial institutions and their suppliers, and EU DORA is very detailed and is an excellent example of technical, well-written law. So this is not a coincidence that EU NIS 2 directive starts with policies. They expect you, cybersecurity professionals, to have policies. Okay, they expect you to have a comprehensive cybersecurity strategy, including but not limited to incident handling, business continuity, supply chain risk management, security of systems that you acquire, including M&As. You have to continually assess the effectiveness of your risk management, cybersecurity training and awareness, encryption, human resource security and training, asset management, asset inventory, MFA. But in a nutshell, regulators from around the globe, they increasingly expect you to have a holistic, risk-based, threat-aware cybersecurity strategy. They don't want you to have state-of-the-art cybersecurity controls. Okay, they don't want you to have 24/7 SOC center with the industry leading experts. Now, they want you to have meaningful cybersecurity strategy that you can explain. And for example, if you decide to conduct penetration testing annually or biannually instead of running continuous penetration testing, red teaming, blue teaming, and bug bounty in parallel, that's fine. You just need to be able to explain why you decided to run your penetration testing biannually and how did you define the scope. They'll certainly ask you, how did you define and prioritize your targets? And if you say, well, listen, we have an Excel file on our network drive, and well, actually, we've been always doing like this, they will be really unhappy. So they expect to have strategy, processes, and evidence of compliance, because trust me, the worst thing you can do is to have state-of-the-art policies, procedures, but when regulators knock to your door loudly, you say, well, listen, unfortunately, our previous penetration testing report is unavailable, and currently our SIEM is under management, is under maintenance. We cannot do much now. We don't have access to our logs. This will be a disaster. Okay, so evidence of compliance is essential. So let's talk about US state law, I would say, so by the New York Department of Financial Services. Okay, though from a legal viewpoint, it would be a little bit imprecise to call it a state law, but let's have a look on their requirements. So for financial institutions that are defined broadly, okay, they expect to have cybersecurity program, okay, and it's not just a cybersecurity program, in vacuum. It has to be based on your risk assessment, okay, and recent risk assessment, and I would even say ongoing risk assessment. They also expect you to have cybersecurity policies. So program is your strategy, high-level overview, okay? But you also need to have policies. This is very important, okay? And I'd like to emphasize here that they expect you to have policies approved by board of directors. This is important because regulators are telling and sending a crystal clear signal saying, no, cybersecurity is not just an abstracted task for tech folks. It is something where board members shall be personally accountable. Okay, this is important. They also expect to conduct penetration testing and vulnerability assessment. They expect to have evidence, okay, audit trail, okay, of compliance. And for example, if you have a penetration testing report, that's great. Probably, if you have an external audit or an investigation, first thing, regulators, investigators, auditors, you name it, they will ask you for your policies and procedures, and then for evidence. And once you give them, for example, your penetration testing report or your SIEM logs, they will ask for remediation, and they'll ask probably like, okay, you have a critical risk vulnerability. What's your process? What's your approach to address critical risk vulnerabilities in this specific segment of your network, and why? How did you develop your policy saying that in this specific isolated segment of our network where we don't have regulated data, for example, PHI or personal data, we accept, mitigation within 30-day period. They'll ask you all these questions, okay? And if you don't have answers, it can be problematic. Cybersecurity personnel, obviously, third-party risk management, super important and super hot now after all these disasters, third-party incidents, and obviously, incident response plan. We'll talk about it in a moment, okay? Once again, they expect to have strategy, processes, and evidence. This is very important. PCI DSS, that is enforced since April 1st, okay? Also, some quick examples. They expect you to have a strategy, to have processes, procedures, policies, and evidence of compliance, okay? So some people believe that PCI DSS is like, annual exercise to conduct, pen test and quarterly ASV vulnerability scanning. No, and specifically with the fourth version of the standard, it was made, crystal clear that they expect you to have, continuous, ongoing, regular risk assessment, testing, and mitigation of the discovered threats and vulnerabilities. So it is not an ad hoc or annual or biannual exercise anymore. So let's talk about data breach disclosures and notifications, certain specific points that can be helpful. So let's start with the following doctrine. Okay, not every security incident is a data breach. Okay, and not every data breach is a reportable data breach. Let me give an example. Let's say I have my iPhone that is locked, and we presume that it cannot be accessed, and I forget it in my office. My office is open to some other employees, for example. Is it a security incident? Arguably, yes, because I have some sensitive data in my iPhone, and if other people can come into my office and take my iPhone, that's not really good, right? But let's say I forget my iPhone in my office for 30 minutes, then I remember that, oh, I forgot my iPhone, I get back. We check CCTV recording, and we see that nobody has entered into my office during this period of time. Is it a data breach? No. Okay. Then let's say I have a USB key that is properly encrypted, and we presume that encryption is not breakable. Then the USB key is stolen. Okay. And finally, we managed to recover it somehow, but we have no evidence that any data on the USB key, and for example, we had an Excel file with some customers' information there. We have no evidence that any data from the USB key has ever been accessed or copied, and we still believe, based on scientific evidence, that it was impossible to break USB key encryption. Is it a data breach? I would say arguably yes. But is it a reportable data breach? Meaning, do you have a duty to notify authorities, to notify customers whose encrypted data was on this USB key? I would say that's a good legal question, but probably not. Okay, so each time you have a security incident, ask whether it's a data breach, okay, because every single attempt to exploit, non-existing vulnerability in your system, for example, script kiddies are still playing with log4j internet wide scanning, okay, is it a security incident? Yes. Is it a data breach? No. Moreover, when some thing happen nonetheless, for example, your system is compromised, but there is no personal data, no regulated data, this is a completely isolated standalone system, is it a reportable data breach? Unlikely. So consider regulatory requirements to report, talk to your lawyers, okay? And pay attention that it's not just about privacy law, okay? It's also about, all these complex laws and regulations we saw at the beginning, because some laws that have nothing to do initially with cybersecurity, they may have duties relating to data protection. For example, the SEC cyber security rules, they are not really designed to protect individuals from having their data stolen. They are designed to protect investors from losing their money when publicly traded companies fail to disclose data breaches that may have serious impact on their stock price. Okay. Contractual duty. This is probably a disaster for many organizations, because if you carefully review all your contracts with your suppliers, with your partners, with your clients, you will find so many clauses imposing, I'd say, sometimes unreasonably high thresholds of notifications that you should probably talk to your legal department, asking whether they have an inventory of all your contractual duties relating to data protection. Okay. ethical duties. This is super important actually, because when we talk about data breaches, I would argue that transparency is super important. When you over disclose something, it is bad. And I observed several disastrous cases when a company initially announced that everything is compromised. 2 days later, they announced, that only 50,000 clients have been impacted. And once again, rectifying, saying not 50,000, but 500,000. This is a disaster when you have inconsistent or confusing communications about data breach. Same as when you are trying to minimize or downplay, saying, well, listen, we'll just say that we are investigating, nothing is known, and stay calm. That's bad, okay? You should provide, clear, I'd say sufficient details relating to the incident. Of course, you may not be able to share all the technical details, or when you collaborate with law enforcement agencies, they may require you to refrain from certain disclosures, but make it transparent and make it actionable. Explain people how you are trying to mitigate the risks and what they can do to mitigate their risks as well. This is super important, actually. Okay. Let's briefly talk about investigations and responding. Okay, that this is a interrelated topic. Okay, so incident response plan. Okay, I saw probably thousands of well-written and poorly written incident response plan. What is important is to have a multidisciplinary incident response plan where you clearly define what your lawyers will be doing, what your PR team will be doing. And yes, in large companies specifically, you need to have an external PR agency with experience to respond to data breaches, because how you deal with media is essential. Because if you simply ignore their comments, they'll probably write a lot of interesting things. They'll do some research. I mean, journalists are creative. They will probably make such a headline that your CISO will have a heart attack. So it is very important to coordinate your incident response, not only with authorities, law enforcement, data subjects whose personal data was compromised, but also with journalists in a clear, transparent, to the best possible extent, of course, and respectful manner. In this case, I'd say that suffering a data breach in a long-term perspective can even bring more credibility and trustworthiness to your company. Because personally, okay, this is my personal opinion, but if a large company has never been hacked, what does it mean? For me, it doesn't mean much, because maybe they've been hacked, but they simply didn't disclose it, for example. However, if you have a large company and you're a client of this company, and the company suffers a data breach, and they help you to mitigate, for example, they offer you free credit score monitoring, they offer you to pay for all your fees to change your IDs, your credit card replacement, and all other costs that you may reasonably incur as a result of data breach, and they explain you convincingly how they will prevent such incidents from reoccurring, I would probably prefer to stay with this company, saying, listen, they've learned the lesson. Okay, so I trust them. They did everything they could. They were transparent, they were straightforward, and they were helpful. So I don't see a reason why I should go to their competitor who has never been hacked. Okay. Of course, I'm not suggesting that breached companies are more reliable than companies that have never been breached. But if you handle your incident properly and respectfully vis-a-vis your clients, it can create value for your company, or at least you will get well-deserved respect from them. Okay. For possible litigation, it may be a good idea to hire an external law firm that will actually lead and manage incident response, including forensic analysis, including evidence collection, and all other technical and administrative processes, because depending on the state, depending on the facts, this data may be protected from being disclosed in court, and sometimes this is really helpful. Okay. Another thing, that when you draft your internal investigation policies, and if you, for example, you have a strategy to actively go after cyber criminals and file criminal complaints, it is essential to talk to your lawyers to ensure that your digital evidence collection procedures are compatible with applicable law, and the evidence that you collect will be admissible in court. It can be pretty complicated. So once again, talk to your lawyers. Okay. Be careful, be very careful what kind of data you store, where, how. So having your corporate data flow chart is really helpful. And in my humble opinion, data minimization is probably one of the best strategies organizations may have, because if you don't have data that you don't need, okay, for example, your legacy customers, if you don't have it, it is impossible that cyber criminals will ever compromise it. So data minimization is essential, and it's not just about personal data. It's about logs. It's about backups that you don't really need anymore. Minimize your data on a company-wise perspective. Okay. Talk to your lawyers. Once again, multidisciplinary approach, whether you're currently enacted and implemented policies and a procedure to monitor your employees comply with applicable law. Okay, and it can be very complicated depending on the state where your employees are. And now with working from home, it's becoming extremely complex. But in a nutshell, employers in most jurisdictions, they certainly have right to control how their employees are using corporate equipment, but it has to comply with certain standards. And for example, if you tell your employees, listen, you can use this laptop for your personal needs, and you don't notify them about hidden recording of keystrokes, or that you are watching them with any kind of software, this can be problematic and they can sue you. Okay, so talk to your lawyers whether your monitoring of your employees and external contractors is compliant with law. So it can also be a good idea, okay, it can also be a good idea to establish proactively a contact with your local state authorities, with federal authorities, just in case one day you suffer a major data breach incident. You will already have a point of contact, and it can be very important. And it is generally considered that when you collaborate with law enforcement agencies, it can be a mitigating factor for upcoming litigation if victims of a data breach sue you, for example. Okay, so and also consider talking to your industry peers, for example, from local ISAC, to understand what are the most frequent risks and threats that peers in your industry observe. Okay. So one another interesting topic, and we are almost done. I'm just carefully moving forward on time. So cybersecurity insurance, this is a hot topic, and let's talk about some pitfalls. Okay. So make sure that you understand terminology. Okay. For example, how does your contract define a security incident? Okay, what's the difference between data breach? Is it a reportable data breach, just a data breach, or it's a data breach defined somewhere or somehow? So it is important that you understand every single term, and that you and your insurance are on the same page in terms of what words really mean in your contract. Okay. Make sure that you understand your own duties. Frequently, insurance companies, they impose so many unnecessary, I would say excessive duties, that it may be a good idea to negotiate and listen, we are not doing any business with sensitive data. We are not, collecting health records. We just don't need all this, excessive, set of exercises like monthly red teaming exercises by at least 3 external vendors. So make sure that you understand your duties. And sometimes when you have good arguments, you can convince your insurance to remove certain duties because they will just consuming your time, obviously consuming your budget. But most importantly, when you have too many duties, you'll probably fail somewhere, and then insurance can leverage this against you, saying, well, you didn't comply with your own duties, so we are not paying you anything. So ensure that you retain control over digital forensic and incident response, because some smart insurance company, they specifically say in the contract that once you detect an incident, you call us and our external vendors will come to investigate and to do everything that we want them to do. Of course, they are willing to spot some negligence, some carelessness on your side to later tell you, listen, you didn't comply with this specific requirement, you had outdated software, so we're not paying you anything. So make sure that you retain control in case of a security incident. Review any cap, meaning limits, okay, on any damages, because the question is whether your insurance will pay legal costs of your executives. For example, if your executives, like your CISO, is sued in his or her personal capacity, will this be covered? Okay, and what are the limits? Okay, pay special attention to certain clauses that may be unlawful in your jurisdiction. For example, in Europe, in some countries, paying ransom is illegal. Okay, so we had a case where cyber insurance contractually agreed to pay for any ransom paid to recover data. Eventually, once the company paid the ransom, cybersecurity, the cyber insurance company refused to pay anything, saying that in our country this is illegal. And eventually the case ended up in court, and court said, yes, unfortunately, as a matter of public policy, this clause is unenforceable because you are asking to perform an illicit act, so your insurance will pay you zero. Okay. Pay attention to exclusions, exceptions, and all this legally. So once again, here you'll probably need your lawyers, but don't just hand the contract to your lawyers. Sit down together, explain technical terms to your lawyers. They'll be grateful. And then lawyers can also explain you some legal meanings of certain clauses. Okay. And also, post-incident, post-coverage penalties. I recently had an interesting case. A very happy cybersecurity executive shared with me how great their cyber insurance was, that they suffered a minor data breach, that cyber insurance paid everything, the best lawyers, external PR agency, so everything was 100% covered. 6 months later, I met him. Once again, he was super depressed, and eventually they suffered a much bigger security incident, and their cyber insurance reminded them that they had a clause in their contract that they cover only 1 breach per calendar year. That's it. So make sure that once you report a data breach to your insurance and asking for coverage, it will not have an impact on your future relationships with insurance. Okay. So that's it from my side. I think we are running a little bit out of time, but we still have enough time for questions. Bill, how would you like me to answer? Will you take control of the screen, or shall I start?
I will take
answering?
control of the screen, but right now there are no questions. So let me remind everybody that if you let me go ahead and share my screen so that we have that. There we go. Let me remind everyone, if you have any questions, this was a very comprehensive presentation, so it could be that there aren't a lot of questions, but if you have questions, now is the time to type them into the text chat. We will wait a moment, and if we don't have any questions, I will go on to my part and then circle back for questions. So if you have a question of our presenter or a comment, many of you have dealt with exactly these same things that he is talking about, and you might want to comment on how you had to handle it. So let's take a moment to do that. And then in a moment, if we do not have any further comments or questions, I will move on to the conclusion of the presentation. Okay, Jason asks, you do not need more laws. Can you briefly explain on this comment? Jason said, you said we do not need more laws. Can you briefly expand on this comment?
So that's a great question. And in a nutshell, when I said this, it was about current trend to regulate everything. And certainly for some specific areas like artificial intelligence, we need to have additional legislation. But what I'm talking about, that now we have a trend that many countries are trying to impose new legislation, for example, to regulate blockchain specifically, to regulate generative AI specifically, to regulate LLM specifically, to regulate intellectual property and copyright issues with an LLM training data. In my opinion, this is an overkill, and sooner or later we'll arrive to a point of no return. We'll have when we'll have so many laws and regulation that regulators will simply have no people to enforce them. Courts will be overbooked for the next years, and companies will probably simply decide to pay penalties to avoid compliance because it will be financially, economically, and practically impossible to comply with every single law. And by using the FTC Act as an example, it's a very old law from 1933, okay, FTC Act. But the FTC, the Federal Trade Commission, is aptly utilizing this law, this federal law, to go after breached companies who that underprotected their data. So, and I think this is a great example that almost 100-year-old legislation can be used for emerging areas in technology. So I'm advocating for using existing legislation to control and to regulate technology instead of enacting more and more laws that are becoming gradually more complicated.
Thank you. Keith asked this question: is Congress working on a GDPR equivalent legislation?
Yes, it has been working, I think, for the last 10 years. And now we have another proposed federal legislation that is supposed to be an overarching, comprehensive, country-wide law on privacy. However, in my opinion, it will probably take quite some time, probably several more years, to see federal law on protection of personal data akin to GDPR.
Thank you. Sergey asks this question: what is the difference between GDPR and the USA system of data breach?
Well, I'd say that GDPR, if we're talking about data breach requirements under GDPR, when you have a duty to report and address a data breach under GDPR, you'll probably have a single source of law. It will be GDPR, though some additional European laws may apply. So in many countries, you have not just GDPR that is enacted in all EU member states by default, but you may also have additional national laws that also address certain requirements of data and privacy protection, okay? But it is more centralized. In the United States, if you are a large company and you have customers in all 50 states, you'll probably be required to go and review legislation of all states, because all 50 states have data breach notification laws, and you'll probably have to follow individually each legislation to understand how to notify your customers whose personal data has been compromised. You will also have to consider federal legislation that may apply. You may also consider different rules enacted by agencies. So I would say that arguably, or probably, I'd say, certainly, in the United States, incident response is more complicated, laborious, and time-consuming.
I see that there is one more question from David, but I think we're going to go ahead and park that for a moment. If we do have a second to come back to it, we will. I want to make sure that we end the formal presentation at the top of the hour, and I have just a few more slides. So we'll come back to David's question. We'll have Dr. Kolochenko stay online to answer that one, but let me go through these few slides first. We have two webinars left in our series for the 23-24 academic year. On May 23rd, which is also a Thursday, Dr. Alexander Perry will be doing an introduction to hybrid quantum classical machine learning. So if you're interested in quantum mechanics and classical machine learning, this is an excellent one for you. On June 20th, Dr. Donovan Wright will be defining the DoD roadmap to digital supremacy by effectively adopting digital transformation. And please don't ask me to say that title twice, but I think it tells you everything that you need to know about that webinar. And we certainly encourage you to join us for any webinars that your schedule allows you to do. And just go to captechu.edu webinar-series to do that. To register for any webinars or to view them on demand, you can go to our website, or you can visit our YouTube page and you'll find those on demand there. Capital offers about 20 different degrees, all regionally accredited, from associates to doctoral levels related to cybersecurity and to this webinar. For more information about degrees and certificates offered in cybersecurity, visit captechu.edu fields of study. Now, also, sometimes I know that there are a lot of students, alumni, and faculty on this session today, but if you happen to be a student interested in one of our degrees, we offer master's and doctoral virtual information sessions. We actually have the doctoral one coming up this coming Sunday, and the master's one coming up on this following Wednesday in 6 days. If you're interested in either of those, email GradAdmit and we'll be happy to sign you up for those. No obligation, just give you an opportunity to learn more information. Finally, links to the slides and to the recording will be sent to all registrants. Watch for an email. We have a certificate of completion. This is an example of it here. If you would like one, when I send out the email with a link to the recording and to the slides, all you need to do is respond with the name that you want on the certificate, and I will send that to you. And this the certificate is available to both people joining us for the live session, and also those who watch it on demand later on. With that, I'm now going to return. Let's see, I think that is our final question. We are officially done. It is right at the top of the hour, and you may log off at any time. But with Dr. Kolochenko's permission, we will stay on to answer at least David's question, and I see Mark has asked a question as well. So we'll get this question, and then we'll see on how Dr. Kolochenko's time is working. David asks, should the U.S. government provide a financial backstop to cyber insurance providers for cyber attacks in the same way as the Terrorism Risk Insurance Act and Safety Act provide liability protection in the event of an act of terrorism?
That's a very interesting question. I would probably say that, in my opinion, And it's not just about the United States, it's about European and other countries as well. It can be a good idea to support industries and to provide additional funding for prevention instead of punishing for data breaches. Because, for example, now we see a clear trend that governments, lawmakers and regulators, they're trying to punish. While this is necessary to enforce law, I believe that it may be a good idea, and it will probably bring better outcomes and will make our cybersecurity more sustainable, if you will, to support the most vulnerable industries. For example, when we're talking about healthcare, frequently what happens if a hospital or healthcare institution is breached, it will face an avalanche of lawsuits. It will see snowballing, effect of litigation, and it will also be scrutinized by governmental agencies. Instead, I would advocate to allocate some resources to proactively support healthcare, to ensure that they have qualified people, they have sufficient budgets, and that they can protect data of their patients. So I do agree that prevention can be better than response.
Thank you. We will take just one more question. There are actually two questions left, but I want to be sensitive to everyone's time who's still with us, and certainly sensitive to our presenter. Mark asks, with cyber insurance, is it possible to acquire insurance from multiple companies in order to mitigate risk?
So no legal advice, but I'd say it is possible. Just talk to the insurance companies whether they are okay, because they'll probably appreciate some transparency. And if, for example, you recover your costs from one insurance and then you recover them twice from another company, they will certainly not like this. But if you have, a cyber insurance company that is covering, for example, some segment of your incident response cost and doesn't cover everything else, and you have second company that will cover the remainder, it can be a good idea. But once again, you should probably talk to your lawyers, but it can be a good strategy.
All right, and I do apologize to Nigeria because we won't be able to get to that particular question. But I do thank you. Again, we're over time, and so I have to be very sensitive to everyone's time. I want to thank everyone who has joined us for the session today, particularly Dr. Kolochenko for taking his valuable time to participate in this session and present this information. Has been extremely helpful and interesting. Thank you very much. And for those of you that will be joining us next month, I look forward to hearing from you for that, or with your registration. With that, we will close at this point and look for a copy of the a link to the recording and a link to the slides and how to get your certificate. Thank you again all, and we are now officially and completely done. Thank you.